before the case is opened.
Thank you for coming in today. We are very excited to work with your team on our latest book series. I understand you have reviewed the printing requirements and the purpose pricing.
Absolutely. We've outlined the printing cost here, including our standard charges. Our team is confident in meeting your quality and timeline expectations.
Now, as for the extent printing, I'm verified right. Our frequencies with ownership of all radios, including this, as it has been a very past.
I understand. However, it's necessary to ask if the firm's information contract and user expectation is also situated in our contract requirements, given the cost involved in credited.
I see. But that's not what you like to oversee. How, including house study, that will cover HMEs, limited purchase, partnership also still with us.
The party also the contract and defined with so the ownership remains with us unless we have it was not for us if the firm was never contract in future 3 months.
Alright, let's proceed with the current terms, but we will expect transparency on any additional charges for reproducing the films if needed, and we will need to review the final printing charges, costly to avoid any overcharge.
Understood. We'll make sure everything is clear and upfront. Let's move forward with the terms. We'll start production as soon as the contract is finalized and is subject to final confirmations.
Alright. I'm seeing an additional $28,052 listed here as extra charges for reproducing the film positive. That wasn't in the initial agreement. We already paid for standard printing fees, so why is this additional charge here?
As we discussed, the film positive are our property according to industry standard and our contract terms. The extra charges reflect the cost of reproducing them. Should you need further prints in the future?
If it comes to that, so be it. We will see you in the court. We won't be bullied into paying for charges we didn't authorize.
Then I guess we are done here.
This court is now in session to hear the appeal in the case of President Corporation Sdn Bhd versus Edward Leong and Organization regarding an alleged breach of contract under the Contract Act 1915. The appellant, President Corporation Sdn Bhd, disputes the judgment requiring them to pay the respondents. Arguments.
Thank you, Your Honor. We submit that the High Court erred in finding against the appellant for the following reasons. The first reason is the $500 charge was unacknowledged overcharge. The respondent's managing partner admitted under cross-examination that there was no valid basis for this claim. The second reason is the $28,052 charge for reproducing the film positive was agreed to on the understanding the ownership of the materials would transfer to the appellants upon payment. And the third reason is no valid contract existed to justify the respondent's claim to ownership of the film positive. Under Section 2 parenthesis A and 2 parenthesis B of the Contract Act 1950, a contract is formed when an offer is made with acceptance. The film ownership clause in the respondent's quotations was not part of any confirmed contract. Furthermore, the respondents failed to prove the alleged usage of retaining film ownership. Such a practice is unreasonable and conflicts with principles of fairness.
Understood? Counsel for the respondents, your response to this point.
Your Honor, we maintain that the $500 charge was valid and related additional cost incurred during the printing process, including additional positive books. The $28,052 charge for reproducing the film printing was under industry practice. Ownership of source material remains with the printers unless explicitly agreed otherwise. Additional charge are paid. The film ownership clause was part of our standard quotation terms and was implicitly accepted by the guardian against the printing contract. We further agree that the web user in printing industry support our claim to ownership. This protects printer from contingent engineering this material and ensure continuity of service. Your Honor, the appellants agreed to a $28,050 charge for reproducing film on C438, requiring ownership transfer. However, the respondents claim ownership, citing quotations as invalidations to agree. Under the Contract Act 1950, quotations are binding offers and the contract was only for qualifying orders to confirm. Witness testimony showed no evidence of widespread industrial practice, breaking Twitter's ownership of materials meant for my clients.
Counsel for the respondents, your rebuttal.
Your Honor, the film continued to integral to our operation and protect our business interests. Retaining ownership ensures this material cannot be used by competitors. Witnesses, including representative from us, telecommunicating association, testified that this practice is common. We also view that our protection, which included in the film ownership clause, form part of the contract as they are accepted to the opposition.
Appellant, do you wish to address this claim? Thank you. The court will now deliberate the following key issues. First, whether the $500 charge was valid or an overcharge. Second, whether the ownership of film positive was part of the contract. And lastly, whether the alleged trade usage is reasonable and enforceable under the law. The court will convene shortly with its judgment. After careful consideration of the evidence, the arguments presented, and the principles of contract law under the Contract Act 1950, the court delivered the following judgment of the appeal in President Corporation Sdn Bhd versus Edward Young and Organizations. Ruling number 1, the $500 charge is invalid. The appeal on this issue is allowed, and the respondent's claim for this amount is dismissed. Ruling number 2, the $28,052 charge is valid for the service of reproducing. After careful consideration of the evidence, the arguments presented, and the principles of contract law under the Contract Act 1950, the court delivered the following judgment on the appeal in President Corporation Sdn Bhd versus Edward Young and Organizations. Ruling number 1, the $500 charge is invalid. The appeal on this issue is allowed, and the respondent's claim for this amount is dismissed. Ruling number 2, the $28,052 charge is valid for the service of reproducing the film positives, but does not grant respondents ownership of these materials. The appeal on this issue is allowed. The respondents are ordered to transfer ownership of the film positives to the appellants after payment of the agreed amount. This judgment reaffirms the importance of clarity and the mutual agreement in contract formation. As outlined in the Contract Act 1950, it also underscores that trade usage to be enforceable must be reasonable and widely accepted. The court thanks both parties for their submission. This session is now adjourned. From the present Corporation Sdn Bhd versus Edward Leong and Organization case, I learned the critical importance of fiduciary status in corporate governance and the role they play in maintaining trust and accountability within an organization.
The case highlights how ambiguity in contracts can lead to disputes. Both parties assume different interpretations of ownership and responsibilities regarding film positives. In practice, contracts must clearly define all terms, including ownership clauses, to avoid future conflicts.
The case underscores the need for businesses to draft detailed agreements, document communication, and avoid relying on assumptions to prevent legal conflicts.
The case highlights the importance of clarifying contract and mutual agreement. As the lawyer of respondent, my role is to defend my client's position and ensure their interests are protected within the boundary of law.
As the lawyer for the appellant, my role was to advocate for President Corporation's interests, primarily focusing on contractual disputes and clarifying ownership rights under the Contract Act 1950. I had to ensure that the appellant's arguments were robust and adhered to principles of justice and fairness.